rise. Superior Court of Guam is on session. The Honorable Chief Justice Catherine A. Merriman is presiding. Please be seated.
Good morning.
Morning.
We have Justice Manglonia sitting as Justice Pro Tem. Can both of you see him on your monitors? Okay.
Yes, Your Honor.
And I'll ask the clerk to please call a case.
This is Supreme Court Case CVA25-015, Oxford Properties and Finance Limited and Oxford Guam Incorporated, Plaintiffs' Appellees, v. Christine A. Lee, aka Anna Lee, and Hello Lee Global Guam Incorporated, Defendant Appellants. Appearing for Defendant Appellants is Attorney Braddock J. Huseman, and appearing for Plaintiffs' Appellees is Attorney William B. Brennan. Panel consists of Chief Justice Catherine A. Merriman, Justice F. Philip Carbolito, and Justice Pro Tem John A. Manglonia. Attorney Huseman reserves 7 minutes.
Justice Manglonia, could you hear? It seemed a little low to me. You can hear?
Yes, it is very clear. Thank you. Good morning, everyone.
Good morning. Thank you.
Good morning, Justice Manglonia.
Morning.
Okay, then we'll proceed. Mr. Huseman, you may begin.
Thank you, Your Honor.
Did you reserve any time?
I did 7 minutes, Your Honor.
Okay, thank you.
I will attempt to anyway.
Okay.
I'll try and keep track of my time as well.
Can I
Morning,
view,
Your Honors.
Can I view counsel, please?
I'm sorry,
Pardon?
Can I see counsel on the?
Shelter, can you?
Okay.
No, can you bring him in closer, the close-up?
Yes, I'm able to see Mr. Huseman, Brad.
Okay.
Thank you.
Good morning, Your Honors. Madam Chief Justice, may it please the court. The parties to this case have litigated it for about 10 years.
You're going to have to speak a little louder for me.
Excuse me. Is that better? Okay, thank you. The parties to this court have the parties to this case have litigated for about 10 years. Despite that fact, counsel for Oxford walked into the Superior Court Clerk's office, informed the Superior Court Clerk's office that the Lees had not answered or otherwise defended the lawsuit, and asked for an entry of default. Despite the fact that the Lees had answered the original complaint, filed a counterclaim, and had litigated the case for about 10 years, the Clerk of Court entered an entry of default. The trial court compounded that error by getting every legal issue put in front of it incorrect. It used the wrong test, used the wrong definitions within the test, switched the burdens, and ultimately granted a default judgment against the Lees, despite this court's holding in Mid-C that default judgments are rare and that judgment on the merits is the preferred outcome. So this case is really about two issues. First, whether the clerk of the court can enter a entry of default when the alleged defaulting party is actively litigating in front of the court, and two, whether this court's holding in Mid-C means anything, or if the trial court has established a new strict liability test for default judgments. The remedy we're asking for today is reversal, vacating both the entry of default and the default judgment, and we're asking the court to remand the case to the trial court for decision on the merits. With my time today, I'd like to discuss 4 issues. The first is the standard of review. The second is the void or voidable entry of default. The third is the trial court's application of the Mid-C test. And the fourth is the trial court's error in granting default judgment. Turning first to the standard of review, I think the standard of review is in 2 parts. First is a question of law, whether the entry of default by the clerk of court was done correctly, that is de novo, it's an issue of law. The second standard review is for the trial court's refusal to set aside the entry of default. That is a two-step test under the Ninth Circuit. The first is a de novo review of whether or not the first step is whether the trial court got the legal tests correct. And then the second step, which is reviewed under abuse of discretion, is whether the court's application of the rule was illogical, implausible, or without support in the record. Critically, every error the trial court made here is a first step error. So we think this is a de novo review of everything. I'd like to turn now to the void and voidable entry of default. The clerk's office should have never entered the entry of default in this case to begin with. The rule is that a clerk's entry of default is void if the alleged defaulting party is otherwise defending. Here, there was plenty of evidence that the Lees were otherwise defending. They answered the original complaint. They brought a counterclaim for $1.4 million. They litigated the case for literally years. This included mediation, an attempt or attempts at arbitration, scheduling orders, appearances, and there were discovery fights in this case as well. In fact, there was a trial date scheduled just months after the Oxford sought the entry of default, and the day that Oxford asked for the entry of default from the clerk's office, the Lees filed an opposition to a motion to compel, which was part of a discovery dispute the parties were having.
It's a little difficult for me to understand the void argument. I mean, if there was a mistake here, then this is something that should and can be corrected. But void suggests to me that from the outset that there was no power, that it was completely with no basis. If there was an exercise of discretion, doesn't that suggest that maybe that conduct may be voidable?
I do think it is voidable. I will agree with the court that it's voidable, but I will also say that I think it is void. We've cited in our briefs to Wright and Miller and to a report from the federal judiciary on this very rule and this issue, and this does prop up from time to time. And the idea here is that if there is, that the Wright and Miller says that the clerk's duty isn't perfunctory, that they actually have a power to make sure, and they have a duty to make sure that the alleged defaulting party is actually in default, right? They're not defending, they've disappeared. And if there is evidence in the record, we think it's void. But whether it's void or voidable, I think is, I think it qualifies under both. But I do think that the Superior Court clerk lacks the power if there's evidence in the file that the party has appeared, that they are actively defending. We've also cited Ninth Circuit cases, I think they're district court cases, that indicate that it's void ab initio.
So, Mr. Huseman, the clerk and the clerk's office is empowered to decide what is the defense that was brought by the defendant. In addition to failure to plead, there's that other or otherwise defense. So the clerk of court has to decide that too, make that decision. And if it's a wrong decision, that it's voidable or void.
Well, what I would say is, in that case, the clerk of court, and this is, that's why we provided the report from the federal bench. The clerk of court then, I think, has a duty to, if there's any question of what's going on or whether this party is actually in default or whether it's otherwise defending, the clerk of court should contact Chambers and seek Chambers' advice as to what's going on. And so if there is any because default is also a two-step process, if there is any question on behalf of the clerk's office, they should really check in with Chambers and make a decision, because without satisfying 55A, the entry of default, then the party seeking the default isn't entitled to a default judgment, and it stops this problem we have here today from starting. So I don't know that the clerk's office needs to get into making decisions about what does or does not qualify as otherwise defend. I think that should be left probably to the chambers. But if there's any question, right, that the party has made an appearance and they're still in front of the court, then that decision needs to be kicked up a bit to to chambers, I guess is what I would say. Because it isn't just a situation, you can have a situation where a corporation is represented by counsel and then decides to withdraw from the litigation. And they've made an appearance and they started the lawsuit, but then at some point they've just disengaged. And at some point, the opposing party is going to want a default judgment because the party has withdrawn. They should be entitled to a default judgment, but not necessarily, that needs to be made to the court, and they need to seek remedy. They need to seek that remedy. But it doesn't necessarily just left up to the clerk's office, especially if we're talking about what is and is not otherwise defend. Does that answer your question, Your Honor?
Thank you.
But here, I think the clerk lacked the power to issue the default against a party that was actively litigating the case. And that's why we say it was void. But we also say it was voidable because in this case, there is a waiver argument as well.
And that's the reason why it's more my understanding that we're talking about conduct here that may constitute a waiver on the part of plaintiff. I mean, you enumerate all these factors that has gone on in this case that suggests that plaintiffs had no objection and continued, as you have said, to litigate with the defendant. And I don't want to be caught up too much. There are other more important points in reference to this case. But when you suggest no power on the part of the court to enter, I think of jurisdiction, personal subject matter, just whether or not a mistake has been made, that goes more towards the voidable.
And I wouldn't necessarily, the only reason I would push back on that is there are district court cases within the Ninth Circuit, and this court does look to the Ninth Circuit that actually say it's void. But I understand the court's point. As long as it's voidable, it is correctable, either by the district or the trial court in this case, or this court. And for our purposes today, I'm not sure the court needs to make a decision on whether it actually is void or voidable. But here, as the court points out, the amended complaint was filed in July of 2018. The parties litigated this till late January 2025. They were 2 months away from a trial date, maybe 3 months away from a trial date, and in the middle of an active discovery dispute. And for those 7 years, there was never a complaint that the answer wasn't filed. And remember that there was a stay put in place by the trial court initially, so the answer wasn't due. And then we had the death of not only the client representative, but the original attorneys as well.
But it seems, if I may just ask, but it seems like the trial court was concerned about the length of time that the new counsel took. I mean, I know that you're saying all the request or application for entry should not have been done, but then Judge Delahaye said, well, new counsel had 18 months to review the files in court, and there was no request to file a late answer to the first amended complaint. And then I was also thinking that back in 2018, you had that 8 days after the first amended complaint was filed to file an answer, before the motion to compel or the motion to stay was filed, you still had that 8-day period. So.
Sure,
that's my
and
concern.
I think that goes towards the trial court's misapprehension of the term culpability in the case. So I'm not here to say that the answer was filed or that it wasn't a mistake. That's obvious that it was. But the 7 years and the problem the trial court's talking about, the delay in filing the answer cuts against Oxford seeking the default as much as it cuts against my client. In other words, it's indisputable that both parties didn't understand that there was an answer missing from 7 years ago. And yes, there was maybe 8 days that I'd have to go back and check, but I'm happy to rely on Justice Manglonia's recollection of the record, that there was an 8-day gap that they could have filed before the stay was put in place. But it's undisputed that it wasn't filed. But the 7-year delay, again, cuts against both parties, is why it's voidable. It's waived. Oxford has waived its ability to seek a default based on its conduct. If we've cited cases that indicate that a couple of months, 4 months of litigation as usual conduct waives waives a party's ability to get an entry of default. Well, this is 7 years. And so I respectfully, Justice Manglonia, I think that delay cuts against both parties equally. It's a problem here. Both attorneys should have paid closer attention to their file. That's true. But I don't think the cure here is the ultimate sanction of dismissing not only the answer, but offhandedly dismissing the counterclaim as well when there's no case law cited to do it. It's just an assumption like, well, I guess that goes away too. And I don't believe that is the case law. We've put that in our brief. I don't believe that's the correct remedy either.
So you argued that the trial court erred when it found that the defendants when the court found culpable conduct on the part of the defendants. And so what's your best case for that you can point to for us to interpret what culpable conduct means, and how is it that the trial court erred in finding that the defendants were culpable?
So we've cited a bunch of cases. Signed personal check number 730 requires, that's a Ninth Circuit case. It requires that culpability means acted with bad faith, took advantage of, in this case, Oxford, tried to manipulate the judicial system somehow. Like, that qualifies as intent and bad faith. And the reason the Ninth Circuit uses that is to set aside an entry of default is a lower standard. It's the same, let me back up. So we have an entry of default and ultimately a default judgment. Those are two different tests, and two different standards, but the same test, which in this case is the mid-C test. And so it's a lower burden for an entry of default, and culpability in this case still always has to mean intent, and intent always has to mean to take advantage, to abuse the system in some way, to try and game the system in some way. Oxford has cited several cases where we think that is exactly the case, where the defendant is engaged in settlement discussions, but then avoids service, the default is taken, then the default judgment is taken, and then they try and set that aside. We don't think we dispute any of those cases. Our best case is that culpability cannot mean you were on notice and you didn't file an answer, and in this case, constructive notice, and actual notice. I'm not disputing that the Lees didn't have actual notice, they did. But if you turn culpability into notice, and actual or constructive or both, then you're by default changing the mid-C test from what it is into a strict liability test. Because any time, and almost every time, you're going to have notice. That's the whole point of Rule 4. You're going to have notice. You're And if there's whatever mistake there is, well, did you have notice? Did you answer? No. Okay. Everything's admitted, and it shrinks what is a two-step process. Rule 55 is a two-step. You need the entry of default, and then you need the default judgment, into a one-step process, which is also a problem with what the trial court did. But back to your question, I think we've cited a bunch of cases, but I think our best case is the Ninth Circuit case, the blank check, which requires intent, and the intent is bad faith manipulation. I want to, before I yield the remainder of my time, I want to basically talk about the default judgment. Now, I know the parties dispute that there was an actual default judgment put in place here, but from the Lee's standpoint, there was obviously a default judgment put in place, and it was done erroneously. So here, the trial court failed to set aside the entry of default. But once you set aside the failing entry of default, it's not a mid-C test anymore. It's the idle test, or in this case, this court has adopted the idle test from the Ninth Circuit in its case, Adams. And so it's the Adams test, and it's a 7 or 8 step test on whether the Oxford is entitled to a default judgment. And it is Oxford's burden to bear, and it's an equitable test. And the trial court didn't do any of those things. It didn't mention the Adams or idle case. It didn't run that test. It switched the burden from Oxford to prove that it was entitled to a default judgment to the Lees to prove that a default judgment shouldn't be granted against it, and it was a circular reasoning because the court assumed that since the default, the entry of default admitted the facts, there was nothing left to do but decide the dollar amount. That is completely backwards. The idle test rejects that idea. It is a 2-step test. There was no second step here. And the court erred in granting the default judgment and, again, switched the burden. And so I see I have a little bit of time left. If there are no...
Well, before you said, what about prejudice to Oxford if the default is set aside? Is that something that exists in this, the circumstances of this case?
No, not at all, Your Honor, because here, and this goes back to the waiver argument, the parties have litigated as usual for 10 years. 2 months before they asked for the entry of default, there was 2 months prior, there was a trial date scheduled for April of 2025, I believe 2025, 2026, whatever the date is. In January, they asked for a default. In April, there was supposed to be a trial. This case should have been over by now. The problem here is not prejudiced to Oxford. It's prejudice to the Lees. And so I don't believe there's any prejudice at all. I'll yield the remainder of my time, or reserve the remainder of my time for rebuttal. Thank you.
Mr. Brennan? Mr. Brennan, could you adjust the microphone?
Yes, Your Honor, I apologize. I'm a little bit under the weather, so I'll do my best. But Madam Chief Justice, and may it please the court, Judge Terlahi was simply not satisfied with the Lee appellant's explanation for spending over 18 months in this case and not realizing that an answer to the first amended complaint was never filed. The clerk of court and Judge Terlahi adhered to the plain language of Rule 55. They conducted an inquiry, entry of default occurred, and when a motion to set aside that default came before the court, he analyzed the factors and he found that the Lees were culpable in that default being entered. So the briefing in this matter really presents the court with 2 questions. The Lee appellants asked the court to increase the burden on the clerk of the Superior Court and her subordinates. They want you to mandate that the clerks below conduct a laborious and substantive review of every application for entry of default And if there is some suggestion of defense in the file, refer the matter to chambers. Importantly, it's not entirely clear that that procedure would have changed anything in this case in the first instance. But in contrast, the Oxford appellees asked this court to recognize Rule 55's plain language, and that is Rule 55 as it exists in the Guam Rules of Civil Procedure, not the current federal version. Where a request for default is presented, the clerk must determine whether an answer or other responsive pleading is in the file, and if a defendant is defending as has pled or is defending as provided by the Guam Rules of Civil Procedure. From there, if a default is entered, the Superior Court is empowered with the discretion to grant relief from that default, which is precisely the procedure that was followed here. Your Honor, I intend to address each of the arguments raised by the appellants. I think I'm going to start, though, with the low-hanging fruit. I anticipate I'm going to get a bunch of questions on the factor test. So on the issue of whether a default judgment entered, I think this is the simplest issue for you. They filed a petition for interlocutory review, which means there is no final judgment to appeal from. So I think it's clear from the record, no default judgment is entered. We're at the stage of entry of default. The Rule 55B1 and 2 analysis would come next. Obviously, it's 2 here, and that's what Judge Terlahi suggested, that he's going to notice a hearing to take care of that.
But there's no question that a default was entered by the trial court,
That's
separate and apart from the entry of default.
No, Your Honor, I think a default was entered by the clerk of court on January 13th.
The entry of default.
Correct, and the Superior Court denied a motion to set that default aside. That's the posture, and then a petition for interlock followed. Now, whether the Lee appellants say that has the effect of a final judgment, I don't know that that could ever be the case because our jurisdiction follows.
Didn't the court's order say that as to liability, that had been now determined and only thing remaining was damages?
I'm sorry, Your Honor, I had trouble hearing.
Didn't the court in its order say that liability had been determined through the default and all that was remaining was a hearing on damages?
That's correct, Your Honor, and we think that's in aid of its determination that it may issue judgment, right? I mean, the cases cited in both briefs recognize that there would still be an inquiry to Mr. Husman's point. We'd still have to do the ATEL analysis, and that would be what we view as the next procedure. So just assuming you were to affirm and remand, that would be the proceeding to determine if and to what extent a judgment should enter. And then a final judgment, if we were to prevail on our claims in that type of proceeding, would enter on the record. That's a default judgment.
So your argument, if I understand, is that the only issue in front of us is whether or not the clerk erred in entering the entry of default under 55A, and that since there's no judgment entered, we need not dwell on whether or not Judge Terlahi has any judgment to set aside? Default?
Correct. I
By
don't
the
think you have to get to default judgment. I do think the interlocutory review also encompassed his denial of the motion to set aside. That is on review, and we view that as ripe for appeal. And I mean, we concede you've granted interlock by permission. So that would be our position on the default judgment. On the argument of whether the default was void ab initio, again, our Rule 55, as it currently exists in the Guam Rules of Civil Procedure, is where a person against whom affirmative relief is sought fails to plead or otherwise defends as provided by these rules. That last clause was left out of both the opening brief and the reply brief of Mr. Huseman. As provided by these rules has to mean something. As we put forward in our brief, there are authorities pre-2007 that suggest that as provided by these rules, if you look at that in a strict construction, means an answer or a motion that tolls the time to file an answer, which would be under Rule 12, right? And in fact—
Wasn't there a stay issue, though?
There was a stay issue, Your Honor. Yes, it's not clear, and there is no authority in the briefing that I saw that suggests a stay in and of itself would excuse the time to answer, right? There are some authorities like I think it was the Ritmark case cited by Mr. Huseman that suggested, a motion for improper venue as opposed to a motion to dismiss for lack of personal jurisdiction wouldn't say the time for an answer. So I'll just say that. Rule 12 does say or as ordered by the court, so it would appear that, perhaps a stay would extend the time, but even so, an answer was due at some point after July 11, 2018. I mean, the court will also recall during COVID, all deadlines, were extended at 90 days at a time for, I think, a 2.5-year period. So, there was never an analysis done like that because Judge Terlahi focused on those 18 months since Mr. Walsh's firm entered an appearance below.
So mediation was unsuccessful, and then there was the issue of arbitration. When was the date where the attorneys determined that arbitration was not successful? And I ask this question so that we can have an idea of, a reasonable time that the defense could file an answer to the First Amendment. They have 2 days left, or what? 10 days?
Understood, Your Honor. I understand the question. I think the best response I can give you is if you look at the status hearings during the period from, the stay initially till Mr. Maher unfortunately passed away in 2022, the report to the court was having difficulty finding arbitrators. I think there was also an issue with the Cantonese interpreter. Ultimately, the parties stipulated a scheduling order and discovery plan, meaning the case, if there was any stay, it was over as of that day on February 20, 2024. We think that would be the appropriate date. But again, turning to the void ab initio argument, we think that those words, as provided by these rules, have to mean something. And it was curious when I saw the reply brief and, our argument was criticized that we're citing outdated authorities. I'd note that the authorities we cite are all interpreting the pre-2007 federal rules restyling, which included the language as provided by these rules. After 2007 is where you get every single case from Mr. Huseman's brief, and these are all district court cases, and I'm going to point something out about those cases in a second, with the exception of one. And that's the Boulder, I think it was called the Great American Insurance Company. It was a 2005 Eastern District of California case. It's the only one that they cite that precedes the 2007 restyling. But even so, if you look at each of their district court opinions and you read them closely, I'm talking about SHFL, Nichols, Brown versus California, Persina versus Sang, Sereno, McCreary, all of those cases discuss, and if they want to rely on cases initiated or being litigated by pro se litigants, I suppose that's the authorities they offer. But if you look at all of those cases, they all acknowledge that the motion for default was improper because there is a motion pending, motion 12, a motion under Rule 12 to dismiss. So I think we have to, if I could make a comparison, Justice Mangonia, in the NMI, as of the 2019 iteration of their rules of civil procedure, they've adopted the more recent federal language, which stops as fails to plead or otherwise defend. So their language, our friends up north don't have the language as provided by these rules. We think that's key. We think the authorities we cited, even though they're a little bit older, interpret the correct iteration of the rule, and a strict interpretation actually, to your point, Justice Carvalito, I think it would be voidable. I think any entry of default that the clerk exercises a ministerial or clerical function, I think it would be voidable because the Superior Court always retains jurisdiction to control those ministerial functions. Here, the clerk didn't have a choice. Once it was shown by application on January 2, and later the amended application on January, I believe it was 11, that there was no answer and no Rule 12 motion that would have told the time to file an answer, the clerk didn't have a choice.
Well, it's not only answer, but it also, the language is otherwise defended. And so when you look at the record, the clerk was faced with the decision whether to enter the entry of default, and it must examine whether or not the defendant answered or otherwise defended. And when you look at the record, there was an original answer. There was a motion to compel arbitration. There was discovery participation on both sides. There was a mediation that was undertaken, and then both parties said they were ready for trial. So when you examine the record and both when the clerk of court sought to determine whether or not an entry of default should be entered, or even with the trial judge in examining whether or not it should set aside, it is confronted with the issue, did the defendant otherwise defend in this matter? And how is it that we can say that the defendant did not in light of all these actions that have transpired?
So, Your Honor, so I'll just be clear. First, again, our position is the rule goes on as provided by these rules. Otherwise defend as provided by these rules has to mean something. We've provided you authority that suggests it's a strict interpretation, answer, or motion. But setting that aside,
Yeah, but if we go down and follow your interpretation in terms of what these cases stand for in terms of as provided in these rules, then you're changing the mid-C culpability test to a strict liability test.
I don't believe we are, Your Honor, and I'll explain. So the entry of default is, the mid-C test is not relevant when the clerk of court is reviewing the file. We don't want a deputy clerk sitting at the window saying, well, who's culpable? Are there meritorious defenses? I think that was Justice Manglotnia's, very pointed question to Mr. Huseman. Do we want the clerk to be, what constitutes defense? Some of the case law says, if they try to engage in settlement discussions, if they're legally sophisticated, that's not, that's.
What about the trial court and when it is confronted with the motion as to whether or not the entry of default should be set aside?
Your Honor, when the trial court gets there, that's why the trial court has such a flexible good cause standard, and that's why the mid-C test exists. And that's exactly the analysis Judge Terlahi engaged in. He looked at mid-C, he looked at this court's endorsement of Ninth Circuit precedent. You asked Mr. Huseman what are the best cases, or what's his best case? He offered the In Re Personal Check. I call that the Messel case. I've read it way too much. But that case also recognized that there was an unsophisticated party. It was a civil forfeiture case. The gentleman that received the civil forfeiture notice filed the administrative paperwork, but he didn't answer in court, which was the other thing he was supposed to do. And the court said, it's clear from here, he's filing the administrative claim, he wants to defend himself. That's what Messel said. And if you were to put the Ninth Circuit cases actually into two baskets, the difference between sending the administrative claim in, well, I'd assume in a customs forfeiture, CBP would receive that actual claim, and so they'd have notice of whether there's specific defenses, specific denials, because that's typically what's in an administrative forfeiture that you have to mail in. It's somebody else's account. You have to raise your specific defenses in that regard. That's my recollection of the administrative process. So if I were to look into the Messel court, they were saying this is an unsophisticated person. He's not legally sophisticated. He looks at this complex web of forms he's getting from customs regarding forfeiture. He sends one of the forms in not knowing there's a multi-part process that also includes filing a claim in court to preserve your ability to receive the funds if a forfeiture action is filed. I think that's a difference, is that customs would still receive that pleading in some form. And it would be preserved as of that time, right? Within the timeline. I think Messel could have come out differently if he was untimely in responding to the administrative forfeiture notice. But if you look at the Ninth Circuit cases, you could put them into two baskets, right? So you have Messel, unsophisticated person, customs form. You have TCI, that had to do with a woman trying to get life insurance benefits. The court emphasized there, she's not a sophisticated legal party. She's a distraught widow. She's seeing a psychiatrist. She's taking psychotropic medications. She's moving across country as this widow with her two young children. And then the last case, it happened to be a Guam case. It was the Falk v. Allen case. Landlord-tenant, the tenant doesn't speak English, she traveled to Korea. So those cases clearly emphasized, the Ninth Circuit clearly emphasizes these are unsophisticated parties. They don't know the consequences of defaulting. In contrast, if you look at the other Ninth Circuit cases, as recently as Castro, 2025, actual or constructive notice and failure to answer for legally sophisticated party will result in denial of a motion to set aside
Yeah,
the default.
but my reading of the TCI case and the Mesley case, there the Ninth Circuit kind of evolved after the Pioneer case, the U.S. Supreme Court 1993 case, and it declared that culpable conduct, requires intentional, willful, deliberate, bad faith, failure to respond. And it specifically rejected the automatic culpability that there's a strict liability. You don't find an answer, you don't file pleading, therefore you're culpable. And that was reaffirmed by the Mesley case. And so there the court said simple carelessness is not enough. And so when Judge Delay was confronted whether or not the defendant acted with culpability, all the factors and the events that had transpired, it's difficult for me to understand how the defendant's conduct was culpable under the various tests of the Ninth Circuit that has evolved after the U.S. Supreme Court case in Pioneer.
Yeah, I think, and that evolution continued is how I'd answer that, Your Honor. You look at franchise holding, 2004. The defendant thought that the settlement negotiations were sufficient, and so long as they participated in good faith, they wouldn't get defaulted. And the court said, no, you're a legally sophisticated party. There's deadlines here. The default's not going to be set aside. Same with Alan Newman. You had a media executive. The complaint was laid at his feet. There was information in the record. His lawyers were aware of it, tried to retain California counsel, legally sophisticated entity. I think whether Oxford is responsible or did anything under the authorities is irrelevant. I mean, and that's just, it may not be a satisfactory answer. I know what the court is getting at, right? And we could provide some explanation, but nothing in any of the Ninth Circuit precedents suggests that the plaintiff, has some responsibility or has to explain their side of what is culpable. It's a focus on the culpability of the defendant. And what I was getting at is if you continue down those line of cases, there's Meadows versus Dominican Republic, there's Hawaii Carpenters. All of those cases emphasize a legally sophisticated party. In those cases, they're, direct mail specialists. They're looking at who has an attorney, who has, legal acumen, is participating in other litigation. And what do we have here? What Judge Terlahi focused on. We don't just have one counsel, right? Because I understand the point, Mid-C, don't punish innocent parties for their counsel's work. But we don't just have one lawyer. We had initial counsel, 2018 to 2022. We had a second counsel who initially entered in 2022, October. But then we have a third party substituting as a party defendant who is also an attorney. So I think Judge Terlahi, to your point, Justice Carbolito, was emphasizing that the legal sophistication that mattered here is not just we have a lawyer representative party, and to your point, Justice Merriman, I should say, I apologize, Chief Justice, I'm still getting used to it. It's not just that there's a legally sophisticated party represented by counsel. You have a lawyer who's a third-party representative who's now sitting as the defendant. And there is still no explanation for why it took 18 months, right? That's kind of what Judge Terlahi highlighted, and he stopped at culpability.
Isn't it relevant that the parties were highly engaged in litigating the case and, sought an arbitrator, went through mediation, went through extensive discovery, and so how is it that we can just look away from that, and especially in light of what's my understanding of the modern standard now, and that the Ninth Circuit seems to have evolved in reference to culpability, and there it suggests you must have some kind of intentional failure, bad faith, deliberate strategic conduct when both parties were highly contesting this case and were so consumed, and then just before trial starts, the plaintiff discovers that an answer was not filed, and sought to take advantage of that.
Your Honor, I disagree with that, recitation of the record completely. I think if you were to look closely, I'd note we didn't submit supplemental excerpts. We let them control the record here. There was one discovery dispute, and if I could paraphrase my recitation of the record, they came onto the case, they waited several months and did nothing. They finally said, give us everything you gave to Mr. Marr. We gave the paper, they called it a dump of 11,000 documents, and then they came back and they said, give it to us in a way that lets us understand this case. And then specifically, at the excerpt of record, page 398, counsel for the Lees freely admitted, it's very hard for us to provide discovery responses because we don't have anybody with personal knowledge and we don't have a corporate representative. So I think
in addition to Justice Carbolito's statements, I'm still struggling with or otherwise defend, because when I was looking at the excerpts, I see about 140 entries by the clerk's office before the entry of default was filed. And then the excerpts of record, hundreds of documents, hundreds of pages that we had to go through in the excerpt. So, don't you think that's otherwise defense factor is satisfied with 140 entries and files and files in the clerk's office? So that's what I'm struggling with here now.
And I appreciate that you're struggling. I appreciate the question, Your Honor. Again, I'm going to stick to my guns that we have an interpretation of why our rule should be more narrowly tailored. But if I could just contrast, litigating in this jurisdiction with some experience, the volume of documents in an action, I think, is not necessarily a direct indication of whether a defense exists or a party is defending.
Yeah, and for the clerk to just file that entry of default, knowing that there are tens of entries made by their own office, that's something has to be corrected with that. One of the recommendations is refer to chambers to make that decision. I don't know what the SOP is, but yeah, something should have been done.
Well, Your Honor, if that's the case, though, if there is this movement to reform the rule, just kind of dispense with 55A and allow the Superior Court judge to do it, this court retains jurisdiction to amend the rules. Just take out 55A and say if a party wants a default, file a motion. File it under 55B1 or 55B2. Why do we need the clerk of court to have this clerical and ministerial function if we're going to be requesting that they conduct substantive review? Just let the trial court do it. And here, we could have got to Judge Terlahi's decision, I think, quicker. But my response to your question, Justice Carbolito, is I don't view this as a case that was being hotly contested or litigated. There was one discovery dispute. There was a dispute essentially that they wanted all the documents and they wanted it in a pretty package, and they weren't going to get it because it's not required under the rules. That one discovery dispute that took 9 months because of, you'll see the delays and who caused them in the record, I don't think that in and of itself means they were otherwise defending.
Shouldn't we though also consider as part of the factors to determine in terms of setting aside whether that it would have been proper or not, that number one, there was a court order stay that existed for years. The stay was never lifted as far as I see the record. Although, there's a debate here and a disagreement in terms of whether or not the defendants were actively litigating and participated in discovery and was preparing for trial, that, under these circumstances, there could be some reasonable belief that the answer deadline had not restarted. And maybe conclude that the problem here is simple carelessness, that there was just an oversight. And that's not sufficient under MITSE in terms of culpable conduct and as to determine whether or not the parties considering all these factors, the defendant was culpable in reference to not being entitled to have the entry of default set aside.
I would just contrast that again with information systems that says simple carelessness of a legally sophisticated entity is sufficient. And that's what the Ninth Circuit has held. I recognize that Pioneer and the other cases have come and gone, but if you look at the basket of cases that focus on legal sophistication, they have found that constructive notice is sufficient. Carelessness can be sufficient. And Your Honor, again, the person who is in the best position to make this determination was the trial court judge, and he was not satisfied with the explanation provided and found culpable conduct.
Yeah, but he seemed to have administered the tests incorrectly. In reference, when you look at the record, I see, at least the way I viewed the record, that there was negligence on the part, or there was carelessness. I got to watch the word because there are other consequences as a result of that. In reference to not filing an answer to the amended complaint, but when you look at that the desire that, cases be decided on the merits and the evolution of the consideration in terms of what's culpable conduct, even under the Ninth Circuit in light of the Pioneer U.S. Supreme Court decision, there just seems to be more. That may serve the interests of our legal community, that be the case. Now, to your argument that, we can't hold the clerk to make all these determinations, that may all well be good and fine, but we can surely hold the trial judge to make the proper considerations in applying the law of our jurisdiction.
Understood, Your Honor. And if that's what needs to be done, and that this court wants to distinguish certain cases of the Ninth Circuit, perhaps that's what the court could do. But in our reading, Mid-C said we adopt the Ninth Circuit test, and we think the court got it right in applying the Ninth Circuit test that focus on legal sophistication. He pointed out there were 3 lawyers involved here.
So your argument is that so long as the parties are sophisticated, a mistake on the part of one is sufficient for that particular party to be culpable for not, in this case, not filing an answer.
A party that is legally sophisticated could be culpable just by carelessness if the trial court, which has discretion to do so, finds that there's no satisfactory explanation.
But that's a strict liability test, Mr. Brown.
Fair enough, Your Honor. Ultimately, you're in the black robe, but I would not agree. I think there may be an instance.
We're having a intelligent discussion, I would think.
Yeah, understood, Your Honor. And I'm just respectfully disagreeing is what I mean to say that, there may be a case where, perhaps in 2022, right when counsel entered an appearance, they said there's no answer in the file. We're seeking leave to file a late answer. There would have been carelessness in that circumstance, but the court could have found, hey, but you exercised, diligence, you're legally sophisticated, you did your job, I'm going to set aside the default. So if we had moved after Ms. Lee passed away or Mr. Maher passed away and realized there was no answer, maybe the inquiry would have been different and it wouldn't be a strict liability test. And I actually suspect that if this same test was being employed then, things may have come out differently. That's just my guess. Again, I'm not the one that gets to decide these things, but I wouldn't view that as strict liability. Even though Judge Terlahi didn't reach meritorious defenses and prejudice, because you asked, Mr. Usman, may I just address those 2 points before I conclude? So on the meritorious defense factors, we cited to cases, and actually I think the cases they cite are in agreement that, just bare allegations aren't sufficient to meet the meritorious defense. In fact, the Mid-C test says you have to include competent evidence. What did they offer here? They just said, look at our counterclaims. First, Judge Terlahi never said the counterclaims are done. They can try and pursue those if they think they're still valid. We've cited some authorities where we think, they're not, but that was never specifically addressed. That's not, as we see it, part of this interlocutory appeal. Superior Court has never determined that the counterclaims are done. He just said, I'm not going to set aside the default on the plaintiff's claims. We're going to go on their judgment is my recollection of the decision. They would need something more. And what we tried to point out in our brief, and maybe, even though he didn't get to meritorious defense, Judge Terlahi kind of saw this vein, was that we don't have the person who was the corporate representative or the initial personal defendant in this case who filed the initial counterclaims and made those allegations through counsel. And again, looking at the record at 398, they freely admit we don't have access to the personal knowledge anymore concerning this matter, so we can't even respond to your discovery requests. We think that there is a lack of their ability to present meritorious defenses, which is why they just regurgitated the initial answer and counterclaim. You'll notice it still alleges in the record, or in its proposed form, that Ms. Lee is a resident of Guam, an officer of the corporation. Of course, she's not since 2022. On the prejudice factor, Your Honor, I do think, there is prejudice to be suffered here for the same reason as the meritorious defenses. And if I could just conclude, Your Honor, with the court's permission. We were preparing for trial. I think you'll find a couple expressions in the record where counsel for Oxford Below expressed this is going to be difficult. We don't think you can meet your, the burden for your counterclaims. Again, because the principal of this corporation passed away, because they will have difficulty finding people with personal knowledge to advance their claims, we don't see how they can just present their meritorious defenses as counterclaims. And then if you look at the affirmative defenses in their proposed answer, they're just, the claims are barred by latches, the claims are barred by waiver, they don't have a business license. These aren't specific articulation of fact of competent evidence. I mean, some of the authorities we cited, need affidavits, personal testimony. You don't necessarily have to prove by preponderance of the evidence, but you have to allege facts with competent evidence. So even though Judge Terlahi didn't reach meritorious defenses or prejudice under the mid-C test, we think the court does have independent grounds to affirm on those bases. But as I said at the beginning, Your Honor, we think Judge Terlahi and the clerk of court got it right. They just adhered to the rule as it exists in our rules today, that is the Guam Rules of Civil Procedure. And the court has the two options. I think if you adopt the Lee appellant's option, the clerk of court's job's going to be a lot harder, and so are her deputies. And while that may be so, having experience litigating in the Superior Court, I'm not sure if that is the best way we can help the court function better downstairs. For those reasons, we'd ask the court to affirm Judge Terlahi's decision, unless the court has further questions.
You're up. Time is up.
Thank you, Your Honor.
Mr. Huseman, I'll give you an additional minute and 45 seconds. So that
Thank you,
would
Your Honor.
make it 9.5 minutes.
Pardon?
I'm giving you extra time, a minute and 45 seconds.
Thank you, Your Honor.
You may proceed.
So, and I would defer to my friend on the other side as far as knowledge of the record. He's obviously worked the case. I have not. I've just got involved on the appeal. But it seems to me that there was more than one discovered dispute here. There was a motion to compel the head, I believe is the shareholder or the head of Oxford, to appear for a deposition in Guam. Judge Scola ordered that. I don't believe he has yet appeared, but he's happy to file declarations on why he should be able to avoid a trial and appearance on Guam through this default. So I think there are more than one discovery dispute over the history of this case. But I wanted to touch on Judge Carbolito asked my best case, and I understand my friend on the other side has said that his best case are franchise holdings in Castro. I would like to point out that franchise holdings is a case involving a default judgment where the parties never made appearance. Same with Castro. They're both trying to remove default judgments, which again, under the mid-C test, a default judgment is a more difficult standard. There is a judgment that the court is trying to respect as far as finality. Those are more difficult to remove than an entry of default. It's the same problem with Castro. We pointed out in our briefing that isn't really much of analysis, and to get the facts, you have to actually look at the concurrence. And those, again, those are cases where the defendant never made any appearance. And here, there are 10 years worth of appearances and otherwise defending. Without covering the ground again on void and voidable, I'd like to just, unless the court has other questions, discuss the trial court's mistakes as far as the mid-C test go. So there are, I think, two prime mistakes with the court's application, the trial court's application of mid-C. First, it used the wrong definition of culpability, and we've covered that ground. Culpability cannot mean what the trial court says it means if it used the term 5 times and never once defined it. And if it used any of the Ninth Circuit cases to define culpability, it becomes in immediate conflict with the way it used the term. And the way Oxford is asking the court to use the word culpability, it is a strict liability test. It collapses Rule 55A and from a two-part test to a one-part test, and destroys how the current rules are set up. And so the court misapprehended the term culpable, but then the court also used, and it cites cases where the defendant is trying to, again, remove a default judgment. The default judgment and an entry of default by the clerk's office are both the mid-C test. They're both those three-prong tests. But again, to remove a default judgment is a stricter standard. It is more difficult. That is the standard the court used. My friend from Oxford didn't counter that in its briefing. We think that is conceded. That is an error that the trial court made. This court is free to review that de novo. I think that the trial court, when it was presented with all these facts, made errors at each step of the way. It didn't use the correct definition, it didn't use the correct standard, and then it shifted burdens. And those are all errors that need to be corrected. My client is entitled to have this entry of default vacated, the trial court overruled, and we're asking this case be sent back down to the trial court so that we can have a resolution on the merits. Does the court have any other questions?
Justice Vignonia?
No questions.
Justice Gerard?
All right.
Thank you, Mr.
Then
Huseman.
thank you for your time.
Thank you.
The court will take this matter under consideration and issue a written opinion. At this time, the court is adjourned. And I would ask that the audience please leave because we'll need to meet with just the 3 justices. Thank you.